Mr. Chairman, thank you. Director Squires, how did you come to file those trademark applications for the Board of Peace?
Thank you for the question, Congressman. We came to file, I had them filed in response to a immediate cyber squatting land grab of the domain name. And for those who are unaware of the term cyber squatting, it's like identity theft.
So were you acting as a lawyer for the Board of Peace at that point?
No.
So in what capacity were you acting?
Well, the Board of Peace, this is exactly the issue, and I'm glad to have the opportunity to explain it and respond to your letter. The Board of Peace has not yet been formed as an international organization. And the cyber squatters, 8 minutes into the president's speech announcing it, registered the domain name. And so
is it a public entity, the Board of Peace, or is it a private entity?
At this point, I'm not sure if it's formed or not. We acted as a custodian so that they could have the mark.
How did you come to act as a custodian for that trademark?
Under 35 USC Section 3, it's my responsibility to advise the President through the Secretary of Commerce on matters of national security and all matters of intellectual property. So the Board of Peace is a public entity. It's a governmental organization, even though Congress has not created it. Is that right? Sir, I don't know the status of whether it's an entity formed or not.
Okay, well, how did you get involved in it? Did the president call you about the cyber squatting incident?
No, the president did not call me. It came up through several organizations about the cyber squatting, and the action needed to be taken to.
When you talked about the cyber squatting, you noted that there were lots of other organizations that were already using some variation of peace organization, Peace Committee, World Peace, and so on, right? There are dozens of them. I mean, I found them this morning just on the way in.
Well, again, a reference was made to Shakedown. This was registered, this particular boardofpeace.org. And without that, you don't have the ability.
You registered that?
No.
Oh, who registered?
A cyber squatter did. I mean, 8 minutes into the
But you don't have to talk about a cyber squatter. There are dozens of other groups that have peace in their name. Right? Well, look, where does your legal authority come from to file trademark applications on behalf of this Board of Peace, whether it's a public or private group?
It comes from the combination of 35 USC 3 and 35 USC 2 under the Lanham Act and in your opening statement.
Well, wait, do you usually act as a custodian for the intellectual property rights of other entities, or is this just for President Trump?
This was to protect the name Board of Peace as the entity gets booted up, to act as a custodian in a very narrow capacity with a bona fide intent to use the name, and then it's a intent to use application.
Who has the bona fide intent to use it?
The USPTO.
The USPTO, what are you going to do with it?
In the very limited services that we define there, which is fraud, prevention, misuse.
But is that a service you offer to all American citizens? In other words, if I'm thinking about maybe creating a group one day and we might want to have a trademark and I'm afraid somebody else has a competing trademark, you will go ahead and file the application for me?
My responsibilities are, again, under 35 USC Section 3 to advise the president on matters of national security.
So this is a matter of national security? Okay, let me ask you this. You've emphasized today, and rightfully so, the importance of people who are applying for patents or trademarks to pay a fee, because yours is a fee-paid office. How much does it cost for someone to seek a trademark? When you applied for that trademark for the Board of Peace, how much does that cost?
It's not an expensive fee, depending upon.
The website says $350. Is that right?
Generally, yes.
It's not expensive. Okay, and my one of the able lawyers on my staff just passed me this. You filed a petition on January 21st, 26 to waive that fee for the Board of Peace. Then you granted that petition the very next day, which underscores the bizarre conflict of interest you're in, now acting both as a representative of the Board of Peace and also the trademark office that's going to pass upon the petition. But why did you seek a waiver for the $350 for the Board of Peace, and why did you grant it?
The waiver was sought under the particulars of the intent to use application as the custodial filer, and I did not grant my own application.
Well, your signature, as I'm reading it, You filed this on the 21st, and then you approved it on the 22nd.
Well, I would like to see the document to which you're referring.
Okay,
but,
we will get you those documents. Are you saying you would not have approved it had you seen it?
I'm saying I don't recall this particular situation.
Okay,
but I do believe it's in
your
my authority.
signature.
Yeah.
Okay, it was approved by Dan Vovanisi, but your signature is on the petition. And I guess,
yes.
Why did you request that waiver of the $350 payment for the Board of Peace?
Again, given that this is going to be an international organization, given the situation with the intent to use and the bona fide limited scope that we had, I made that petition just as I signed the application, and it was granted.
Okay, and then
by someone
finally,
else.
you know that the Lanham Act forbids anyone from submitting an application unless they're the owner of the mark or the legal representative of the mark. So were you representing yourself as the owner of the mark or the legal representative when you filed the petition?
No, we are very clear. It's on a custodial basis. We are not the owner. It will be transferred to the entity once it's formed.
Okay, well, you're listed as the owner on the petition, both for the waiver and also the application. So, I mean, that's the way the Lanham Act works. In other words, if I'm asking for your advice, could I get another company to apply for a trademark for me? What's the answer to that?
If you're the President of the United States, yes.
The President of the United States could have somebody else. The President of the United States has tons of trademarks. So you're saying that he doesn't have to submit himself? Where does it say in the Lanham Act that the President of the United States is exempt from the general rule that you cannot have a third party seeking an application on your behalf?
I'm, again, directing you back to USC 35 USC Section 3, where it's the Undersecretary of Commerce and Director of the Patent Office shall advise the President on national and certain international intellectual property policy.
Those are matters of public policy. They're not questions of representing the president before the Trademark Office, which obviously creates a stark conflict of interest.
The gentleman's time has expired, but you may answer.
Sir, I was not representing the President of the United States in this regard. I was representing filing an application to address the cyber squatting issue under my authority under 35 USC.
I appreciate it. Thank you. I yield back, Mr. Chairman.
Thank the gentleman. Just one question for understanding. The gentleman from Maryland mentioned a number of other uses for peace and so on. Under both common law and any marks they have, those marks are previous, superior, and are not eclipsed by this new mark. Is that correct, to your understanding?
That is my understanding. It was a very narrow filing for the logo and the name. And again, it was an intent to use application. If nothing happens, it expires of its own weight.
And just one thing, because I'm a little new to government, but you're in the Article 2. You're in the government that's headed by one person, the president, right? And no matter how many pockets you have in your suit, it's still one suit jacket, right? So the $350, if it had to be paid for by the government, can you tell me the difference between all these different places in the government that would transfer $350 to another pocket of the same suit? Because I'm not quite understanding the gentleman's question.
Mr. Chairman, are you saying that it is a governmental body in that case?
Well, it appears as though the President of the United States made a statement that either it would be a government entity or like Voice of America and many of these other entities that are government sponsored, it would be government sponsored. I think there's been no assertion that this was a for-profit private entity or anything of the sort.
The Voice of America doesn't get $1 billion from the Saudi government. That would make it an illegal, unconstitutional foreign emolument. I mean, this is just getting more confusing by the moment here. Is it a public?
I share with the ranking member questions of other monies that are not necessarily associated today. And I'm quite candidly willing to participate in all the fact-finding on anything related to money. But the gentleman came here with tremendous expertise, and I think your line of questioning was very good as to how, at times, the Trademark Office does, in fact, institute protection against cyber squatting. You're also very helpful in delineating the fact that there are these entities that aren't quite government, but are government, that have trademarks, one of which is the Voice of America and many other highly recognized U.S. entities, which are solely funded by the federal government. I think it's been productive. I will join with you to continue looking at questions of monies from other governments, whether or not they're coming to the government or that they're going to a third party, because I think that's a fair area. I just don't think it's within the gentleman's expertise.
All right. Well, I would welcome a thorough ventilation of all these issues, just so we don't go down a dark road here. Thank you.
Thank you.